We're back waiting for live testimony in the Bradsher case. Right now, court is actually in recess. They are on a lunch break, but we anticipate that they will be coming back soon. We've been listening to the testimony of David Whitley. Now, he was the lead investigator on the case. And in this clip, there was a real focus on his testimony about Cindy Blitzer, who is the subject of this case, you know, the person who allegedly didn't have any work to do but was still being paid, who reported to Bradsher that Bradsher knew that Cindy didn't have work. Some of this testimony that she had told him more than once that she didn't have enough work to do, and Bradsher had never taken any action. So this has really been the focus of part of Whitley's testimony in this clip, and I'm interested to hear what our esteemed guests have to say about that. So we still have Michael Bachner, white-collar criminal defense attorney. We have him in studio, and we're also joined by Robert Ekstrand. He's also a criminal defense attorney, and he's in North Carolina. Welcome, gentlemen. Thank you so much for being with us here today. Robert, welcome. Me and Michael have been here all morning covering this case, and we're happy to have a little insight from you. So before we get into Whitley's testimony, I want to know a little bit about this jurisdiction. I mean, we have a former district attorney representing himself in a court where he, you know, has been practicing and has worked for many, many years. What do you make of this? Do you have any insights on the locality?
Well, sure. Both of the jurisdictions at issue, obviously this is a conspiracy. One of the prosecutors has pled guilty and has yet to be sentenced, but he appears to have an eye on what's called a PJC. He's testifying for the state and cooperating with the state and has done that. You know, the other obviously the defendant in this case, who's representing himself, is also a prosecutor. They're both from very rural counties.
Thank you for joining us here on the Law and Crime Network. Again, we are still waiting for the Bradsher court to come back in session. But in the meantime, we've been listening to testimony from the lead investigator, Agent Whitley. So in this segment, we have absolutely seen that there is a focus by the prosecution on the fact that Cindy was asking for more work, that Cindy was saying that she needed work, that she didn't have enough to do. And in this particular clip, we heard Whitley testify about a conversation between Blitzer and Bradsher, wherein she said, look, I'm going to nursing school, that I have to take some prerequisite classes, that she admitted she was going to nursing school and that she would be doing that throughout the tenure of her employment. Now, not necessarily that it was going to be at the same time or full time, but certainly that there was an awareness that she was going to be participating in this program, in this conversation. So I want to bring Michael back in. Michael, so again, we were talking about this issue where Cindy, there's a big focus on the fact that Cindy's asking for additional work, that Cindy is letting the defendant know, I don't have enough to do. Now, what do you think that means for the case? Understanding that Bradsher knew this, if you believe the testimony, and really didn't do anything about it or said, hey, don't worry about it, just focus on nursing school. What's your take on that?
Well, to the extent that it's a believable bit of testimony, Bradsher's position may very well be, look, she filled the position. If there wasn't a lot of work to do, that's not my fault. That's the job and that's the pay. I don't set the pay and I don't set the parameters of the work. If she's asking for more work and they can't get her more work, and as long as she's doing what she's supposed to be doing, and, you know, maybe she shouldn't have gone to nursing school, but I didn't think that was such a bad thing because she was doing the work she was supposed to be doing. They didn't get her these special projects they thought they would get her, etc. I didn't really have any criminal intention. And the fact that Mrs. Blitzer has never been charged with any crimes indicates, I would argue, that the fact that she was not doing that work obviously wasn't a crime. Otherwise, they would have charged her with criminal conduct. So if she's not being charged with a crime for not working, why am I being charged with a crime because she wasn't working? So that may be an argument that he may try to interpose down the road.
Yeah, that certainly could be. I mean, again, you're right that a lot of these statements have been that, hey, we talked to Bradsher about it. You know, we heard from Craig Blitzer. We've now heard from Cindy. We've heard from Whitley that the statement had been, hey, she doesn't have enough work to do. And Bradsher said, don't worry about it. Now, Michael, you bring up a great point. What if there simply wasn't enough work? to go around. And perhaps that's the direction that he's going. Again, I think there have been a couple of common themes with Bradsher's defense that he's brought up, that this was kind of this had been an open situation, that there was nothing hidden. Does the fact that this wasn't behind closed doors really matter for the purposes of proving the crime?
Well, it certainly indicates, to the extent that people generally commit crimes, don't like committing crimes overtly in the open. They try to secret and conceal what they're doing. The fact that it's no secret that she was working for him, it's no secret that she didn't have enough to do, and he didn't set those parameters, and someone else signed off, the judge signed off on his work, on what he was doing. This wasn't Mr. Bradsher doing anything wrong. He's being punished because the district attorney's office hired somebody for whom they didn't have enough work to do, and he's the great foil that they can hold responsible for this. So that may be something he's trying to put together. And candidly, sometimes defendants try and throw a lot of stuff against the wall and see what sticks. And maybe the jury goes back there and argues with each other and says, you know what, reasonable doubt.
Right, exactly. And that's what we know. Look, Bradsher, certainly familiar with that legal standard as a former DA. So he knows what he's doing. I'm sure there's a lot of strategic choices being made. Now, Robert, I'm interested in your take on this most recent testimony. The testimony that we just watched of the lead investigator, Whitley, was focused on the fact that Bradsher was aware that Cindy was enrolled in nursing school. Do you think that this factor is going to weigh heavily in the jury's mind?
It's certainly it's a fact from which you can infer that there was no legitimate, honest intention to have her do real work. And while it's absolutely true that it can't be a crime to hire somebody and then not have enough work on a day-to-day basis for that person to do, if you've seen any prosecutor's office or any public defender's office in probably any state, but certainly in this state, they are staffed very leanly, and their workloads are extraordinary. You know, public defenders will walk into court with stacks of cases, you know, files that big, and they're not necessarily big files. Just they have an enormous workload, and so obviously, if he can prove that this was just a trick of circumstance, that there was no work to be done in Mr. Blitzer's office for his wife, then, or in his office for Mr. Blitzer's wife, then that might give the jury some pause. But I think it would be very easy to prove that these offices have plenty of work, and certainly staff support is the one thing that I think is most on demand in those offices, because I think that's the level at which a lot of budget cuts have hit different prosecutors and public defenders' offices. Not so much the attorneys, but the support that they can get. And it strikes me as an uphill climb for him to be able to demonstrate to a jury that really this is just a trick of circumstance. But then he's also got to turn around and face the charge of obstruction of justice in connection with that investigation of that crime. And there's powerful evidence there, too, that he's got to somehow deal with.
Yeah, absolutely. Thank you so much, Robert. That is a very good point, and it'll be interesting to see how this all unfolds. Now, Michael Bachner, thank you so much for joining us. I know that you have to leave today. Robert, I hope you'll stick around for a little while,
Sure.
But all of your insights have been great and really helped us to break down all of the interesting facets of this trial. We are continuing to wait for the Bradsher court to come back in session. They are still at a lunch break. In the meantime, we're going to move on from Detective Whitley's testimony. We're going to move into the testimony of Craig Blitzer. Now, he is probably the most critical witness in this case, as he's the other DA that is allegedly concocted this plan for the what they're dubbing the wife swap, meaning that each other's wives were going to work for their respective husbands. So Craig Blitzer, he accepted a plea deal and is now testifying against the defendant. So this testimony, very critical to the case, and we're going to watch it now while we wait for court to come back in session. For for joining us this afternoon on the Law and Crime Network. We're waiting for the Bradsher courtroom to be back in session. They were on a lunch break, and we anticipate that we will be back live soon. In the meantime, we're reviewing some of the critical testimony that we heard earlier in the trial. What we just heard was the testimony of Craig Blitzer. Now, he was the other district attorney that was involved in this wife swap that serves as the basis for the charges in this case. Now, Craig Blitzer is now talking about establishing an agreement to hire each other's wives, essentially, between him and between him and the defendant. So this is what's serving as the basis, laying the foundation for what we know is to come, which is the allegation that Cindy Blitzer was actually getting paid for not performing any work. Now, Robert Ekstrand, criminal defense attorney, we have him via Skype here today to help us break down some of the aspects of this case. Now, Robert, we just heard some of the testimony of Craig Blitzer, and this really seemed to be the type of testimony that's beginning to lay the foundation for what's to come. So Blitzer was talking about the situation where he meets with the defendant and they discuss this wife swap. He says, yeah, they switched jobs. We didn't fill out any paperwork or anything. We just simply decided they would switch jobs because employing them as a husband and wife duo was essentially against an ethical rule. Do you see a red flag here with just this swap-a-roo without more? Is this a problem for the case?
It's not a problem for the state. It's a problem for the defense. And, I think it's just one of those things that it really is transparent. And obviously, what's so crucial to this case is that the state has a conspirator testifying on its behalf. And that's just devastating. It's devastating for a jury to hear again and again, we had this agreement. It was nothing more than we can't do it this way, but let's do it this way. And now we're also hearing that there's this arrangement whereby the wives are not necessarily required to be at the office, which is pretty damaging, because one of the few things that the defense had going for it, if you could call it going for it, is that this was allegedly an open and an arrangement that was in plain view of everyone. How could it possibly be a crime? Well, of course it could be, but that makes it less likely. You'd have to be pretty arrogant to openly engage in criminal conduct. But now that we're hearing testimony that there's this arrangement whereby the wives are working at, or one of them, Ms. Blitzer maybe, is working at home. And that takes a lot of fuel out of what might have been a pretty strong argument that this was all in the open and therefore legitimate. Now we're hearing that, yeah, she was at home and you could stay at home, you could work from home, and she doesn't have any work to do. So it starts to look like she's getting paid for nothing. Again.
Right. And, but Robert, and this is something that's perplexed me since the beginning of this case. And that is such a great point, and very clearly where Bradsher is going with his defense, because we heard him really lay that out in his opening statement, right? That this was in plain view, that others knew about it, that there's nothing fishy going on here because we're not trying to hide it. But what... And this is what I'd be saying if I'm a juror in this case, because we learned that investigators concluded that Bradsher's wife was actually doing her job. She was working for the money that she earned. There was no issue with her employment or being paid for something that she wasn't supposed to be paid for. So that begs the question, what benefit does the defendant in this case derive from Blitzer's wife working, not working and getting paid? And I think that that's something that it sticks with me. Do you think that's problematic from a jury perspective when you're talking about, just practical concerns?
Well, I think the problem is it's not a one or the other. The theory of a conspiracy, an agreement, is that both conspirators, all participants in the conspiracy, are liable for any conduct in furtherance of the conspiracy. So if you have this imbalance of benefit and this sort of dichotomy of, we have one scenario where one wife is working hard and the other one where she's not working at all, what Bradsher's problem here is that everything that went on is attributable to him just as much as it would be to any other participant in the conspiracy. So that's if a jury applies that principle faithfully, it really won't matter as long as this scheme involves some, you know, acquisition of salary, public funds, under the false pretense that she's working for it and that Bradsher intends for her to work for it.
Right. So, Robert, that's such a great point, and I think that really clears it up. Just because the conspiracy ultimately didn't arrive at what would be considered an equal quid pro quo situation, and one person received more of a benefit than another person, doesn't necessarily mean that a conspiracy doesn't exist for the purposes of potential criminal culpability. So I think you really cleared that up for our viewers, because that was plaguing me since the beginning of this case. I'm like, well, why the heck is this guy going to put his neck on the line to make sure that his friend's wife isn't working when his wife is actually doing the job that she was hired to do? So I do think that's interesting. Now, Robert, you mentioned, and I agree with you, that one of the most critical points that came out during Craig Blitzer, who does have a plea deal's testimony, was this statement that, yeah, we contacted Bradsher. We told him, my wife and I told him that we thought it was a little weird. She didn't have enough work to do. Was there something wrong with that? And, he blew it off, said it's fine and whatnot. But do you think that there is going to be a bit of a question mark? Because, look, he did accept a plea deal. He got a pretty darn good deal in the context of this case. So does that blur the line with respect to credibility of his testimony?
Sure. There's always going to be a question about credibility. Anytime you have a testifying witness who has escaped what will probably be a much more difficult consequence by virtue of his cooperation. The problem here for Bradsher in using that is that, this is somebody who he trusted. This is somebody that he even if you accept his theory, he is essentially vouched for the credibility and character of this man because he put his wife into his employ. And there's certainly that. But also, the fact of the matter is this is an elected official testifying. This is somebody who won office and was the elected district attorney in his jurisdiction. And in North Carolina, prosecutors are given and police officers, also law enforcement generally, is really highly esteemed. And they're not. This isn't the typical jailhouse snitch or rat or somebody who's been incarcerated and says he's got a wild story that the defendant confessed to him. This is a reputable person and somebody who seems to be testifying with a real frank demeanor. I don't see a lot of the cues that would maybe lead a jury to conclude this guy's saying whatever he needs to say to get his plea deal as sweet as it can be.
I think that's actually a very good point, Robert, because you're right. We've seen many, many cases that we've covered here on this network where there is an absolutely very clear, almost prejudice with the testimony because someone's deriving such a astronomical benefit for testifying on behalf of the prosecution. But in this particular case, the jury may see it as Craig Blitzer. He's accepted responsibility for what he believes was not the right conduct, and that he is, in doing so, he's now testifying, but not because he's being, coerced or there's some sort of dangling carrot at the end of that testimony that's going to alter the truth. So interesting. We will see how the jury feels about this as this trial continues to unfold. We do anticipate that court will be back in session shortly. The lunch break, which began around noon Eastern Standard Time. So we anticipate that we're probably going to be back in the courtroom in short order. In the meantime, we are going to break for a commercial right now, but we will be back live in that courtroom the moment we have a feed. We were just watching clips from the testimony of Craig Blitzer, who accepted a plea deal in this case. Now, that testimony was the cross-examination by none other than the defendant, Wallace Bradsher, because Wallace Bradsher is actually representing himself in this case. So on that cross-examination, you saw Bradsher trying to poke some holes in Blitzer's story, really recounting many of the conversations that they had regarding this wife swap. Now, we know that Blitzer, Craig Blitzer, the DA who was also involved in this, has already pled guilty and is now testifying on behalf of the prosecution. So it's a really interesting dynamic to watch that cross-examination, because you're talking about Bradsher cross-examining his former friend and colleague as he represents himself in the course of this case. I want to pull in Robert Ekstrand to really break this down, because this has been one of the most fascinating elements of the case. The fact that we have Bradsher representing himself, and not only that, the people that he's cross-examining in the context of the case, all these witnesses, these are his former friends, his former colleagues. It really is quite compelling to watch. What do you make of it, Robert? Is this a benefit or a burden ultimately to the defendant?
Well, I think that the old saw goes that any person who represents himself in court as a fool for a client. That I'm certainly not trying to insinuate that Mr. Bradsher is a fool, but this is a remarkable decision for him to have made. Surely his office has won many, many cases against defendants who made the choice to represent themselves to their own peril. And in this case, what's so unusually difficult about an already difficult proposition, defending yourself, is that he is now cross-examining his alleged co-conspirators, who are at liberty to answer all of his questions in ways that he really does not want them to answer, and in a way that a jury is going to be very impressed by. So, for example, at some point, Mr. Bradsher asked a question and opened himself up to the answer from, I think it was Mr. Blitzer, to the effect that we decided to end the conversation with you as soon as you told us we needed to lie to the investigators. And that's just deadly. And now Bradsher is not in the position where he can retort. He's just got to ask the next question. And what that, trials are a strange way of telling stories. And what happens in an exchange like that is really almost beyond comprehension. It may have ended the case. It certainly was a stunner, and it was certainly predictable. These folks are being very frank and forthcoming, and whether it's true or not, according to Bradsher, they are owning this story, and they are telling this story as though it's exactly what happened. And so in that moment, it just struck me as, wow, the coffin is sealed on obstruction of justice. A jury is really going to be impressed with that. A witness testifying to the accused, looking him in the eye and answering his direct question with a direct answer as damning as that. I don't think a defense lawyer would have allowed for that witness to be giving that answer. And frankly, there may well be a good decision not to examine these co-conspirators at all. I don't know if he's coming out ahead on points after each of these examinations, but the ones I've seen, he has lost. He has lost a lot of ground, and perhaps more than he can make up. And I think a good bit of that is attributable to the fact that he's asking the questions, and the answers aren't coming back the way he wants them to, and he's not able to offer any rebuttal evidence. He's just got to move on to the next question,
right?
Which often is still worse.
Yeah, absolutely. That is certainly a risk that he took in self-representation in a case like this. Well, right now we're seeing some movement in the courtroom. So we're going to go live to the Bradsher courtroom. Robert Ekstrand, thank you so much for your insights on this case. We do truly appreciate it, and especially with respect to the self-representation. We're really looking forward to see how this plays out. We'll hope you'll join us again.
Happy to do it. Thanks for having me.
Thank you. So we're going to go live to the courtroom now. There appears that the court is reconvening after a lunch break, and we're awaiting further testimony from Judge John Schultz. Here's live to the courtroom.
Called